Welcome to the NCDWI Guide podcast, where defenders of the Constitution assemble to prepare for courtroom battle, and firm owners gather to develop marketing strategies that will revolutionize the practice of criminal defense. Here's your host, the NCDWI guy, Jake Minnick.
Hello, fellow freedom fighters, and welcome to episode 123 of the NCDWI Guy podcast. On today's episode, I'm going to give you some best practices for drafting a preliminary indication, something that is more helpful in some jurisdictions than others. There's maybe more state appeals that you might see in one county versus another, but we're going to go over some best practices for drafting a preliminary indication after you have won a motion to suppress on your DWI case in district court. So that's going to be the subject matter of today. Before I dive into that content, though, I want to again encourage you, and the timetable for signing up for this is dwindling, to consider going to attending the Game Changers Summit in Atlanta on November 2nd and 3rd. This is at the Mercedes-Benz Stadium. This is an amazing law conference. It's really, really the best law conference that I've ever attended. All 3 years that I've gone, it has been stellar, and it is going to be amazing again this year. The lineup of speakers is incredible. I cannot tell you how excited I am about this conference this year. At least 13 of us from my law firm will be at the conference. So, put my money where my mouth is. This conference is one that I don't want to miss, and I don't want my team to miss it either. I feel like, having my team spending their time at this conference is that valuable to what we are doing. So again, this isn't just something that I feel like is good just for a law firm owner, or for just a select amount of people. Everybody that can get into this thing is going to benefit from the content and ideas that are conveyed by the speakers at the conference. So I really encourage you to go to that. Would love to see some NC attorneys representing at the Game Changers Summit. So please consider that for yourself, for your team. If you want to grow the culture and the direction of your firm into the future, this is a great place to get some incredible ideas for doing that. So there is the promo. Again, not getting paid, don't have any need to spit that out there. The people at CRISP do not know that I am promoting this conference in the way that I have been over my podcast. So again, truly just, I think, a great way to improve yourself as a lawyer and improve your firm. So let's go ahead and dive into today's content, how to draft a great preliminary indication. So you've won your motion to suppress in district court, and whether it was the breath test, whether you won on keeping the breath test out, probable cause, reasonable suspicion, whatever the reason is, whatever evidence that you've been able to get suppressed, in many counties, that's it. That's the end of the game. If you win the motion to suppress, it is dismissed by the district attorney in court that moment. Preliminary indication a lot of times doesn't even need to be drafted because it's already dismissed by the state as soon as the judge says motion granted. However, in counties where they apparently don't have enough else going on, and there is a lot of these things that get appealed, or just select ones that get appealed, this is some tips on how to prepare that preliminary indication. So the first thing that you want to do anytime that you win a motion to suppress in district court is you want to ask the court to draft the preliminary indication. Sometimes I've seen judges that kind of prefer to do it themselves. I've seen judges that will, sometimes do it themselves. Other times ask the defense lawyer to draft the preliminary indication. And some judges seem to almost always ask the defense to draft a preliminary indication. But there's two main reasons why you should draft the preliminary indication. The first one is, or at least, I'm sorry, the two reasons why you should ask to draft the preliminary indication. And the first one is so that you don't look lazy. Many years back, I had a case I won a motion to suppress on, and I don't remember exactly how the conversation came out, but effectively, I kind of passed the buck to the judge to draft the preliminary indication. I said something to the effect of, I feel like you would be in a better position to write down your reasoning or whatever it might be. I think I was trying to be deferential, but I just sounded lazy. It just sounded like I was being lazy and not wanting to draft the motion. So you don't want to come across as lazy. And that's something that, from the moment I walked out the courtroom, I was like, that conversation just did not go the way that I was kind of in my mind thinking that it went. And I'm not going to ever put that on the judge again to draft the preliminary indication where there's kind of an offer for me to do it, because I just don't want to come across as not being interested in doing that. So take a note out of my my many fail, one of my many fail lessons. Offer to draft the preliminary indication so you don't look lazy. Number two, and more importantly, is that if you draft the preliminary indication, you, not surprisingly, are in control of what goes into the preliminary indication. And some of what we're going to talk about today is going to be important in terms of how that preliminary indication gets drafted. But you want that preliminary indication to be rock solid when it goes up to Superior Court. The DA is going to look at that in terms of determining at some point whether or not to appeal the motion to suppress being granted. The Superior Court judge is almost always going to look at what is in that preliminary indication. So you want it to be rock solid. I had another case early on in practice where I won a motion, and the judge basically drafted the order, the preliminary indication, in the courtroom by handwritten notes on the back of some sort of an AOC form that was like a general order, but literally like hand wrote the reasoning that she had for granting the motion. And I lost on appeal. I'm not going to say that was the only reason we lost on appeal. Judges, may disagree with what has been found by the district court. But again, you want to make sure that the way that the preliminary indication is drafted looks rock solid, clean, tidy. Everything that's in there needs to be in there, because that could be something that goes into the Superior Court judge's mind as to how solidly based is this in terms of a legal decision for me to come down one way versus the other. So the number one tip that I have is offer to draft the preliminary indication so that you don't look lazy and so that you have control over the content, format, layout, logistical setup of the preliminary indication. So that is tip number one. Tip number two comes into the findings of fact. When we're talking about the findings of fact. So when it comes to the findings of fact, what we're looking at statutorily, statute-wise, when it comes to a preliminary indication is 20-38.6 and 20-38.7. 20-38.7 says the state may appeal to Superior Court any district court preliminary determination granting a motion to suppress or dismiss. If there is a dispute about the findings of fact, the Superior Court shall not be bound by the findings of the district court, but shall determine the matter de novo. So that's from 20-38.7A, subsection A. So if there is a dispute as to the findings of fact, then a new hearing occurs in Superior Court. If there is not a dispute as to the findings of fact, then there is no new hearing in Superior Court. And what the Superior Court is actually doing is acting as a court of appeals. What the Superior Court is really doing is reviewing the preliminary indication to see whether the findings of fact support the conclusions of law. And again, maybe reasonable minds would agree to disagree, but I had a case once where a motion to suppress was granted by a district court judge for lack of probable cause. It was appealed up to Superior Court. There was no dispute as to the findings of fact. It was just the state said, we disagree that these findings support a conclusion that no PC existed. And the Superior Court judge, looking at everything, I think very wisely and soundly said, if I heard this case myself in a hearing and this was the facts that came out, then I likely would have found that there was probable cause to arrest. But since the findings of fact are not in dispute, I didn't have the chance to hear the evidence, watch the video that is referenced. Since I didn't have the opportunity to do all that, I'm not going to overturn the district court judge that sat in the best position of making this decision. And that's a great judge. That is a great judge, a great Superior Court judge who is acting as the Court of Appeals. The trial court is in the best position to look at these things, to determine whether or not there is PC, yes or no. And so as a result, I'm going to find that there, in fact, was no PC. I'll agree with the district court judge because I'm just sitting here as an appellate court, effectively reviewing whether the findings of fact found by the district court judge support the district court judge's conclusions of law. So it's really important to think through the findings of fact. So a couple of points on this findings of fact issue. Try, if possible, to make the findings of fact non-controversial, not able to be contested. And so here's an example of this. Instead of putting that the defendant didn't have slurred speech, put that there was the trooper did not at any point testify that defendant had slurred speech. Right? Because again, basically, or if the trooper says, defendant didn't have slurred speech, you can put that in the preliminary indication, but don't try to make the findings of fact don't use those findings of fact when you are drafting the preliminary indication to really make a one-sided case. Try to make the findings of fact as non-controversial as possible while still laying out and giving the judge the basis to then have the conclusions of law that support them granting the motion to suppress. Don't go out of your way to basically say, here's another example. Defendant appeared to be standing straight as a rail during the interaction. Maybe instead put the defendant did not sway during the time that he was being investigated by Officer Johnson, and Trooper or Officer Johnson indicated that there was no swaying noticed. Okay, right. So trying to make it so that they are not able to be contested because you've exaggerated things. Don't exaggerate in the findings of fact. We first of all, we want the truth to come out, but secondly, it's going to hurt your position in terms of there not being a dispute as to the findings of fact. Supports another point when it comes to the findings of fact is try to support each finding of fact with very hard and fast evidence. And so what I mean by this, I generally tend to record all of my pretrial motions and district court trials on a recording when I'm allowed to, and that's most of the time I ask to record district court proceedings. So after I have done that recording, every finding of fact, I will go back through the recording. At every finding of fact, I will put recording at whatever the number is. So minute and second number. So if it says, Trooper Johnson is a Buncombe is a highway patrol officer in Buncombe County. Next to that, it will say recording 5:14, meaning it's at 5 minutes and 14 seconds. I'll do that for every finding of fact so that it's clear that this finding of fact isn't something that the judge remembered, that this is something that the judge kind of had confusion about. It's an audio recording. This is exactly what occurred. And then I'll put as a footnote CCD attached of recording of trial. So I'll actually attach a recording copy of the CD. It makes it impossible for the state to say, well, that's not what he said. It's exactly what he said. It was on recording. In a couple of cases, I've gone one step further and actually sent my audio recording to a local court reporting agency and had them transcribe the recording. So I can actually, by transcript, page and line number, indicate where everything was said. And that's beautiful. I've had a superior court judge that has been looking through my preliminary indication and the attached transcript and is literally reading the testimony that occurred during district court while a de novo superior court hearing was going on. So I didn't in that case successfully get the judge to buy into, findings of fact aren't controverted, because the state said, well, we're disputing the findings of fact, even though there was none specifically disputed. The court allowed a de novo hearing, but was literally reading the transcript during the de novo hearing. So they're just looking at what was said in district court, and clearly it was the exact same thing that was said in superior court. So it was just honestly a big waste of time having a de novo hearing in the first place. But again, you want to lock in the findings of fact happened. Yeah, okay. Let's step back for just a second as we kind of walk through this findings of fact. The state wants to dispute the findings of fact because that gives them the ability to have a new hearing in superior court. They kind of get a new bite at the apple in superior court. But if you make it so that the findings of fact cannot be challenged, that there's not a challenge as to the findings of fact, that they can't say, well, actually, I disagree with that particular finding, then all they really can say is, well, judge, we disagree with the findings of fact. And if they really do not disagree with the findings of fact, which I think actually is the situation in most of the appeals that I've personally had, where the state has said we're challenging the findings of fact, but in reality they're not. They just want a new hearing. Either they should have to state which findings of fact that they are challenging, or there's got to be some sort of a argument that you make to the court that says that there's no good faith basis for challenging these findings of fact. The court, by audio recording, by transcript, has identified exactly where this was said. The state hasn't indicated which, if any, of these findings of fact, particularly that they're challenging. They basically just say, we challenge findings of fact, so they get a de novo hearing. And that's not good faith. I mean, it's not a good faith basis, so that you really make sure that you're asking the court before any de novo hearing in front of the superior court judge, asking the state to identify which of the findings of fact that they are challenging specifically. And I've seen some blog articles and reference points to the fact that maybe the state doesn't have to specifically identify the findings of fact. There's no case law that I can find that says that, but I've seen some indications where it says, well, maybe the state doesn't have to identify that. Why shouldn't they? Why should they not have to identify which findings they are challenging? Because that's the whole reason they're getting a de novo hearing, is because they're challenging it. And if there's really no good faith basis for challenging the findings of fact, they shouldn't just be able to say, challenge, judge, and get a new hearing. They should have to identify which ones they are challenging, and there should be a good faith basis for that. If it's recorded, if it's in a transcript, it's like, well, that's what was actually said. So try to lock in that by hard and fast evidence. Again, if you've done an audio recording, you can use that to get that set. The other thing that I do in terms of getting the state to commit to the findings of fact, and I think this is a really good practical point, is before I present the preliminary indication to the judge, I will send a copy if I've been asked to draft it. I will send a copy to the state, to the DA that was involved on the case, and say, can you tell me, what suggestions you have, what changes you have to this proposed preliminary indication. If you have any problems with the findings of fact, let me know, and I will do my best to change those. And so, I've gotten multiple times notes back that say, nope, no dispute as to the findings of fact, or no problem with the findings of fact, no problem with the order. And so, again, if you can lock this state in before the order is signed that they're not challenging the findings of fact, you could then even put in the order, the state had the opportunity to review the order and has indicated that it is not challenging any of the findings of fact, and verify that with the DA in front of the judge that there's no findings of fact challenge. Hey, I sent you that email asking if you had any problem with the findings of fact. You indicated that there's no findings of fact that are in dispute. Just want to make sure I've added that to the order so that the court can go ahead and sign this. So before you actually present the order to the judge, see if you can get the state to commit to the order as proposed. And maybe there is a case out there, or maybe there's definitely been cases that I've seen out there where there can be a disagreement as to the findings of fact, what the state is arguing and has proposed, what the judge's findings are. But I would say that most of the time, the findings of fact either are not or should not be in dispute. What was presented at district court was presented. The judge, you can agree or disagree with the judge's ruling as to the facts. The state absolutely can disagree with the judge's decision, but the facts themselves should be pretty hard and fast in most DWI cases, right? If you get a case that has multiple witnesses or really intricate issues, then maybe there is a dispute as to the findings of fact. But a lot of times, the only officer that testifies in a motion, or the only witness that testifies in a motion to suppress, is the arresting officer. And so it's kind of like there's nothing controverted. Whatever he says is kind of what was observed. Here's what was found. And there's not any dispute as to what was actually indicated. So be very careful about crafting that and present that to the DA before you present it to the judge, so that you can attempt to get the state to admit that there is no dispute as to the findings of fact. So last point, as to drafting a preliminary indication, third and final point, is as to a time limit. Now, 20-38.7 does not set a specific time limit in terms of when the findings of fact or when the state needs to appeal following a preliminary indication by the court. Under 15A-1432, there is a 10-day time limit for the state to appeal a dismissal of a criminal charge by the court where double jeopardy is not involved. So there's a 10-day time limit there. State versus Palmer, 197 NC App, which is a 2009 Court of Appeals case, said that 10-day time limit does not apply to 20-38.7. Really, there's this kind of reasonable time that the state is allowed to appeal a preliminary indication by the court granting a defendant's motion to suppress. So reasonable time is the time that we're looking at. But what is a reasonable time? That's kind of up for grabs, right? That is not very clear in terms of what a reasonable amount of time would look like. 10 days might be a reasonable time. If that's enough time to appeal a dismissal by the court, I don't know why that would not be a reasonable time for appealing a motion to suppress. Again, the court said that 10-day time limit wasn't specific to a motion to suppress on a DWI case, which is what 20-38.7 governs, implied consent. But at the same time, you could say, well, it's reasonable in this situation. Why not on a DWI? But I think that the better practice here in terms of getting the state to timely appeal or to lose the chance to do so is to have a specific time frame in the order for the state to appeal. And this is something that I've put a time frame limit in the preliminary indication that I've drafted in the past. I've had judges set a time frame for a limitation. What I'm about to suggest isn't something that I've tried, but I think it is a really easy way to get a commitment. So what I would do after your case has been heard in court is basically when they're setting a new date, because typically what will happen after a motion to suppress is granted and there has to be a preliminary indication drafted, is that a new date is set on the district court case, so that at or before that new court date, the state can the judge can actually sign the preliminary indication and the state has the opportunity to appeal. What I would do is immediately after the judge has indicated orally, I'm granting the motion to suppress. Mr. Minnick, will you draft a preliminary indication for me to look at and sign, indicating that I am granting that motion? What you should do at that time is ask the judge to inquire of the state how long they would need to appeal. How much time would be a reasonable time to appeal? So just ask them in open court. Ask the judge, just say, Judge, I'm happy to draft the preliminary indication. I'm asking the court to inquire of the state how long they would need to make a decision about appealing this. Because really, that's the whole purpose of the continuance. So again, I think what you do in that situation is you get the prosecution to decide how long they are going to need to make a determination about appeal. And then in the preliminary indication, you can put in open court, state indicated that they would need until August 15th to make a decision about whether or not they are appealing this. If the state has not filed an appeal before August the 15th, this order will become final. Boom. Now you've locked in the finality. And again, I think that in some jurisdictions, as you know, the day after that preliminary indication is signed by the judge, the state's filing its notice. I mean, it is on top of things and ready to go. But if you have a situation where it's, the judge signs the order and the state just waits around until the next court date and says, well, we haven't decided yet if we're appeal, we still got to talk to somebody, whatever it might be, then you can say, well, actually, this order has already become final because, the state indicated that a reasonable amount of time to make this decision was by X date. The judge gave until that time frame based on what the state informed it, and the decision is now final. Can't be appealed. And I think that would hold up on appeal because, again, the reasonable amount of time was based explicitly on what the state has indicated is the time frame that it would need to appeal. So those are just a couple of tips to think about and consider when drafting a preliminary indication. As district court lawyers, we don't have to write a lot. That's one of the blessings of being in district court, is that we don't have to file. You can, and this actually I think is good practice in other situations, whether it's discovery motions that you're filing or really good motions to suppress, motions to dismiss with memorandums of law attached. I think that drafting quality legal documents can be very effective and powerful in district court. But day in and day out, we're generally, as a whole, not drafting a lot of documents. It's really important to draft a solid preliminary indication. I have what I consider to be a pretty good go-by in terms of a preliminary indication. I'm happy to share that with anybody. If you want to reach out to me, I'd be more than happy to share what our preliminary indication looks like. I am sure that it was stolen from Marcus Hill or Bill Powers or somebody else in the defense community. So, it's not exclusively my own design, but that's a really important thing to focus on, is drafting the preliminary indication nicely, tightly, laying out the findings of fact, laying out very clearly the conclusions of law, making sure that everything just looks by the book and is rock solid so that it has the best chance of surviving if a case goes up on appeal. So if anybody wants a copy of what our preliminary indication looks like, please feel free to reach out to me. If you have a case that's going up to Superior Court, myself or the attorneys in any of the offices, in any of our offices across the state, would be more than willing to talk to you about that. So feel free to give us a call. But spend the time really trying to nail down the preliminary indication. Final note on this front is if you have a case that is potentially going up on appeal, or you're in a jurisdiction where the where the state frequently does appeal the decision by the district court judge to grant a motion to suppress, before you get too far down that road, go to the DA and have a conversation about the case. And, what are the concerns that you see in terms of wanting to appeal this? See if you can talk through that with them, because I do think that there's a fair amount of cases that get appealed and there's really not a great issue to go up on appeal on. And again, I mean, different minds can think differently. So this is not to say that the state is not right in wanting to appeal certain DWI cases. But I think that if you sit down and talk with them about other facts on the case, or maybe, a motion to suppress was granted, and if it's appealed and overturned, you actually have 2 or 3 other motions out there that would potentially do away with the case. Or maybe it's not a good case factually for other reasons, and the state doesn't know that because they haven't seen the case. So there may be other information that you could bring to the state that would discourage an appeal so that you can have a finality and get a dismissal for your client. Again, hopefully this information has been helpful, and I look forward to speaking with you again next time. If you found the information in this podcast to be valuable, I simply ask that you pay it forward and share this podcast with another member of the legal community. Also, if you would leave us a rating or a review on whatever platform you are listening on, I would greatly appreciate it.